Welcome to Tea Time with the Jackson Center. My name is Kristan McMahon, and I have the pleasure of serving as the president of the Robert H. Jackson Center in Jamestown, New York. Today's tea is sponsored by the Jamestown Bar Association. Justice Jackson was a distinguished member of the JBA, which continues to protect and promote the professional interests of its members, foster pride in the profession, and encourage civility and collegiality in the practice of law. The JBA also mentors law students and young law professionals. And so if you are interested in that mentorship program, please contact the JBA and we will post the information to do that. I am excited for today's conversation. Today, I am joined by Munir Ahmed, the Saul Goldman Clinical Professor of Law and the Deputy Dean for Experiential Education at Yale Law School, Armando Ginaglia Sikora and Ramis Wadud, both students in the Worker and Immigrant Rights Advocacy Clinic, or WIRAC, at Yale Law School. And Ramis, Armando, and Munir, thank you so much for joining me for tea today.
Thanks for having us.
So our program theme for this year is The Other Through Your Eyes, and our aim is to give our audience a sense of how the law can shape our experiences, and also how and why the law's impact may vary depending on circumstances. And there have been, I would say, few instances that better illustrate that than the discussion we and the country have been having about immigration, and especially our focus today, the deferred action for childhood arrivals. So I think it makes sense to start with maybe an overview of the Daca program and sort of the impact that it has, the people who are incorporated under it. And I understand, Armando, that you have some personal experience with this. So why don't we start with you?
Sure. So I can give a little bit of an overview of the program as a whole, and then I can talk a bit about my own experience with it. The Daca program emerged in 2012 as the Deferred Action for Childhood Arrivals program under President Obama, as a way of providing protection from deportation, work permits, and some other benefits to undocumented people who had come to the United States as children or as young adults, and who'd been living here for at least 5 years. The Daca program didn't emerge out of nothing. It emerged out of a long decade of advocacy, more than a decade of advocacy by undocumented people and others who had been pushing for some sort of relief, originally in the DREAM Act, and later through executive action, which is what ended up happening with Daca. And like I said, the program gave relief from deportation, the ability to work, so it provided work permits, the ability to travel abroad for special circumstances, and I think above all, freedom from fear, or at least as much fear as people had before. So for me, I was born in Venezuela. I came to the United States when I was 1. I didn't know that I was undocumented until I was about to graduate from high school. And during my first couple years of college, before Daca had come out, I had a lot of uncertainty about what was going to happen after I graduated from college, which I know is an uncertainty that a lot of people experienced before Daca, and is an uncertainty that a lot of people have experienced since 2017, since the Trump administration tried to get rid of Daca. And in 2012, Daca came out. I applied. And Daca provided all the things that I mentioned for me. I was able to graduate and work to help my family make ends meet. I was able to travel abroad for the first time since I'd come to the US for an educational trip. Was able to enroll in grad school, and eventually was able to make my way to law school, where I'm about to finish next year. And I think Daca really shaped my life, not just, like I said, through giving me the opportunity to work and have an income, but also just through the sense of being able to feel like I belonged in some way that was different, and and gave me a sense of freedom from the fear that I'd had before the program existed. Yeah.
Well, and I think that's one thing that on occasion gets lost is that people hear or think undocumented and correlate that with illegal. And so that starts spinning into things that people have done wrong, just sort of that sort of stigma of there must be a reason why you didn't go through this process the way the process is shaped to go through. And so that's, and I think that for the large number of DACA recipients, because they were brought here as children, had really no say in what has ultimately shaped their life in that point. And certainly I can imagine in previous years prior to DACA's, prior to the signing of DACA, that those children, now young adults, had gotten a little lost because, as you mentioned, there are a whole host of things that you cannot do without some sort of paperwork saying you are who you are and you are allowed to be where you are.
I think one of the things that's easiest to lose sight of in talking about that stigma and talking about, okay, what's the relationship between the 10, 11 million of undocumented immigrants to the law in this country. And this was something that shocked me when I first learned about it, was that we are currently in the longest stretch since the Civil War of not having immigration reform of any sort. And what that's meant is that we understand immigration law in a way that is static and unchanging, in a way that's actually really new, even for the United States, which has had controversial immigration laws in the past and tremendous issues with race and national quotas. But this is new in a lot of ways. And so what we've created is now a permanent kind of underclass of individuals who've been here for decades in many cases. So for example, my parents have been here for about 26 years now. A little over 26 years. And they'll have to wait until I become a citizen, probably in about 3 or 4 years, in order to get papers. It'll be 30 years at that point. So this is a field that could be a lot more dynamic and could be resolved quite easily if Congress actually was able to take action on it. But it's something that hasn't been able to happen in about going on 30 years now.
Mm-hmm. Well, and that's something I want to delve into in a little bit, as well as some of the additional advocacy work that is needed in this area. But I think that we should take a step back and talk about really the Supreme Court decision that came down in June. And Ramos, I think I'm going to throw this question to you. If you wouldn't mind giving us just a brief history of the Batalla Vidal case specifically, because I know that WIRAC was intimately involved in that case.
Sure, I'd be happy to. So Batalla Vidal is a case that we work on and filed in a federal court in Brooklyn with our partners from Make the Road New York, the National Immigration Law Center, and the Justice Action Center. The story actually starts all the way down in Texas, years before the Trump administration attempted to terminate DACA in 2017. We had initially filed our case on behalf of Martin Batalla Vidal after a federal court in Texas stopped the implementation of a certain expanded set of protections for DACA recipients that the Obama administration tried to extend in 2014, as well as a different set of protections for parents of U.S. citizens and lawful permanent residents. So after the federal court in Texas enjoined that program from getting off the ground, that court order was implemented nationwide. And our client, Mr. Batalla Vidal, was affected because his DACA protections would have been cut, would have been shortened. because of that court order. Over time, as we were litigating that case, the Trump administration in 2017 tried to terminate DACA in September of 2017. So we used that case as a vehicle to challenge that termination itself. And we were the first case in the country to sue the Trump administration on behalf of DACA recipients against the Trump administration's memo terminating DACA. We were joined by the state of New York and a coalition of other states in the same federal court, other DACA recipients, labor unions, companies, universities, other states and municipalities all over the country. In Maryland, DC, California also filed suit. They worked their way up the courts along with us, and we eventually made our way to the Supreme Court, who consolidated a number of cases in 2019. And the consolidated cases were argued in November of 2019 and decided in November of 2020. So that's a brief history of the case. We're happy to get into the substance and a lot of the meat of the case as well.
Well, and so why don't you also just sort of give the general holding of the court, so people have that understanding as well before we move forward.
Sure. So it requires a lot of process in federal law, but to put it simply, there's a law on the books that requires federal government agencies like the Department of Homeland Security to follow certain procedures and to consider certain criteria before making their decisions, before making their policies. Terminating DACA was a policy decision by the Department of Homeland Security, along with the Department of Justice, and they had to follow the rules more or less in order to do that. And our argument was that they didn't follow the rules. Not only did they not go through the proper procedures, but they didn't consider how harmful this decision would be on the tens of thousands, hundreds of thousands of DACA recipients, their families, their communities, their employers, and other members of and parts of civil society. And the Supreme Court agreed. They held that not only did the Trump administration not think through the decision using the criteria that's required of them, they didn't even give lip service to the interests of DACA recipients who have relied on the program for the 6 years prior, or for the 8 years prior to the Supreme Court's decision. So because of that failure, because of an inadequate reasoning and decision-making process, the Supreme Court set aside, kind of eliminated that attempt and returned us to what the equilibrium was before that, which was the full functioning of the Daca program.
Great. And then I feel as if certainly something that might have escaped the average layperson's understanding of this case, and I say that only because of some of the conversations I have been having about this case, is whether or not this meant that the Department of Homeland Security can't rescind DACA, or whether that program could not be ended at any point. And so if you wouldn't mind filling in the gaps on that too, I think I would also appreciate that.
Sure. So the Supreme Court made clear that federal government agencies have the power to make decisions as long as they follow the rules and consider the right criteria. They only held that in this instance, the Trump administration had failed miserably to do that. The Trump administration, any administration, really has the power to make agency actions. It's how government runs. Federal government agencies conduct the proper decision making and make decisions that kind of dictate policy around the country. So the Trump administration's power to make changes to the DACA program remains relatively untouched. But the Supreme Court did double down on the fact that you have to follow the proper procedures and ensure that you take the following criteria into account. The main one being the interests of DACA recipients and how much they relied on the program.
Thank you very much. And Munir, I think I know that there are next steps coming. You all have been intimately involved and actually had a phone call earlier today So do you want to talk a little bit about what comes next? What does this mean for your clients, and how does this move forward?
Sure. So after the Supreme Court decision came down and it set aside the memorandum from the Department of Homeland Security that sought to terminate DACA, the expectation then was that since that policy had been invalidated by the court, that we would return to the status quo prior to the termination in 2017. And so as we waited for the government to start to accept DACA applications again, and we're hearing instead comments from the Department of Homeland Security saying that the decision had no basis in law and that they were weighing their next steps and that they were just getting ready to repeal it again. We were essentially bracing for whatever the next step would be. And what they did was to issue another memorandum, what's now called the Wolf Memorandum, issued by Chad Wolf, who has or claims the title of Acting Secretary of the Department of Homeland Security, and come back to why I'm describing as in claiming having that, because this is now a big issue going forward. To go back to what Ramis described in terms of what the Supreme Court decided in our case and the companion cases in June of this year, really what the court was saying is that the requirement for government agencies to provide their true reasons for the actions that they're taking and to be rational and reasoned in their decision making was essentially the court clarifying that these are not just procedural niceties. These aren't technicalities and dotting your I's and crossing your T's, but instead these are essential components of government accountability. And it's the statute that the case was decided under, the Administrative Procedure Act, which dates back to 1946, essentially arose at a time when the administrative state was growing. It was in the early years of the New Deal. The size of the federal government was growing, the power of the federal government, and in particular bureaucratic agencies of the government, was growing. And there was a concern that since this was not the president taking direct action, it wasn't Congress passing legislation, it was something that had a kind of quasi-legislative quality to it, but without the accountability of elections, that there needed to be some other mechanism to ensure that the decisions that were being taken by the government were ones that for which the government would be held accountable to the people. And so the Administrative Procedure Act was designed to achieve that by saying, by essentially setting rules, ground rules for how federal agencies could make decisions. And the basic ground rule was that those decisions can't be arbitrary or capricious. Chief Justice Roberts, in deciding the Daca case, quoted Justice Holmes in saying that the government is required to turn square corners. And again, the notion of this is not just kind of to be technically correct, it's to uphold government accountability. So I want to highlight that because where we are now is with another memorandum, this one, the Wolf Memorandum, which has decided that it will not accept new applications from DACA recipients, and it will cut the renewal period for people who have DACA from 2 years to 1 year. And it places very significant restrictions on something called advanced parole, which is essentially a form of permission for people with DACA to travel abroad in the way that Armando mentioned that he had done when he had DACA. So we are now in the process, the early stages of challenging this new memo. And we're back in court, in the same court where we started in 2016, as Ramis described, in the federal court in the Eastern District of New York. And we are in the process now of amending our complaint to bring new claims regarding this latest attempt by the Trump administration to gut the Daca program. I should say that a lot of people, when this memo came out, thought, well, it's not so bad. It seems like, in fact, what the government is claiming is we're really just seeking to preserve the status quo. We're continuing to allow people who have DACA to renew. And just in the same way for the past 2.5 years, we didn't allow new DACA applications. We are still not going to allow them. But that's not what the status quo was. The status quo is what was the state of play before you took unlawful action? And the state of play before they took unlawful action was to accept DACA applications, initial applications, to provide renewals on a 2-year basis and to grant people the permission to travel. And so we are seeking to return to that status quo. And one of the arguments that we are now advancing is that the policy is invalid and must be set aside because Chad Wolf, who has this, or is claiming this title of acting secretary of the Department of Homeland Security, was improperly appointed. And in fact, there's a report that just came out from the Government Accountability Office last week, which is a federal agency that itself concluded that Chad Wolf was improperly appointed. And I mention that because the GAO, the Government Accountability Office, they are all about government accountability. And so if you have the head of an agency who is improperly appointed, who now is making policy that is affecting upwards of 700,000 DACA recipients, hundreds of thousands more who would be eligible to apply for DACA, and then the kind of reverberating effects on families and communities and employers and universities and labor unions and community groups, all of whom are depending upon the continuity of the DACA program, then there's a real problem of government accountability, because you have someone who should not be in that position making policy of enormous consequence. And the remedy in that situation, we believe, is for that policy to be set aside. So that's what we're seeking to argue in the first instance as we go back to court in challenging the actions of the Trump administration on DACA.
Well, and certainly just the general turnover in that head top position at DHS has complicated, I have to imagine, complicated what they're trying to do on that side. And also, as you just described, given the side that is trying to take it back to what it was prior to that 2017 decision, some additional fodder for now it's a completely, maybe not a completely different process or procedure that is out of alignment, but certainly yet another one that falls into that category. I have to say arbitrary and capricious is one of my favorite legal terms, because for me, at least, it always makes me think that someone is paying attention to the human element of it. And so you really need to, as actually all three of you have described, it's more than just the crossing of the T's and the dotting of the I's. It's really taking a look at what is the impact that this is going to have, and have we thought through, or have we given the time to prepare, or what are the next steps for this that we have publicly stated, so people who are relying on these programs have an opportunity to adapt or not be immediately adversely impacted.
Yeah, and if I could just add, in both the first iteration of this case and now in the current one, there are really deep constitutional principles that are at stake. So when Congress passed the Administrative Procedure Act back in 1946, it was very much about ensuring that, placing a check on the executive, that the executive kind of not run amok, particularly when it was engaging in quasi-legislative activity. And so there is a separation of powers concern there, and Congress stepped in essentially to regulate and limit the actions of the executive when it was stepping into this quasi-legislative space. That case was principally about the Administrative Procedure Act. This case now, at least in the first instance, is principally about something called the Federal Vacancy Reform Act. And this is, again, very much about the power of Congress in relation to the executive, and in particular, the power of the Senate to exercise its constitutional authority to provide advice and consent on positions in the federal government that require Senate approval. So, what we're drawing attention to, as others have in related cases regarding policies issuing from the Department of Homeland Security, is part of a much larger phenomenon of the Trump administration making a very, very liberal use of temporary appointments to positions, hundreds of positions throughout the federal government, and circumventing the requirement that the Senate approve, advise, and consents on certain positions, that there be Senate confirmation on a range of positions. President Trump has said numerous times that he likes these acting positions because they give him a lot of flexibility. And it's tantamount to saying that he's doing things through these positions that he could not do if he turned square corners in the way that the court required them to do the last time around. So the case is very much about DACA and the protection of DACA. The principles that are involved are ones that really extend to the structure of our government, and in particular, the ways in which some fundamental principles of how our government operates have been under attack under this administration.
Well, and so one thing, we host the Robert H. Jackson lecture series at the Chautauqua Institution every summer. And this past summer, Ruth Marcus was our lecturer. And she and Professor John Barrett of St. John's Law School had a conversation about this case as well. And one of the things they had pointed out was that, and as you all have stated, this doesn't take away DHS's ability to change the DACA program or things along that line. And in fact, the Chief Justice almost gave a roadmap as to how, if they wanted to do it, the process and procedures that needed to be followed. And Armando, I can see you nodding your head there. And so I think that that's, and Munir, it's going back a little bit to what you said, that it's that process is important, and how you get from point A to point B is part of what matters. And so that leads me to a question of, in addition to these cases, is WIRAC involved in additional advocacy work, whether that be to Congress or the Senate, about perhaps implementing things that would make DACA not an executive order, or implementing protections there if it needs to be done piecemeal, or to the point you just said, how are you pushing perhaps it's oversight of that Vacancy Act to make sure that the process is being followed? I'm gonna go with Munir on that one.
Sure. So so we work in our clinic with a broad range of partners and clients, and on the litigation side, the case that we've been describing has been principally the way in which we've been engaging around DACA and the expansion or the maintenance of protections for individuals who otherwise would face deportation. We do a lot of individual representation of individuals in deportation cases as well, but those are folks who may or may have protections available to them, but that are not programmatic in the way that DACA is. But directly to your question, we also work at the state, the local, state, and national levels in supporting organizations to engage in other forms of advocacy outside of the courts. And so our general approach is to favor working with membership-based and community-based organizations and to lend legal support to them. And that is grounded in a view that while legal advocacy and litigation in particular are important tools, that the kinds of meaningful social change that we are committed to requires different forms of advocacy, including community organizing, policy advocacy, community education, a broad range of approaches, and that litigation is only one, and oftentimes not even the best tool to advance that. So we work, for example, with United We Dream, which is the largest organization of dreamers, of immigrant youth, I should say, in the United States. We work with a Connecticut organization, which is affiliated with United We Dream, which is called Connecticut Students for a Dream, which, if I'm remembering correctly, Armando was at least a member and maybe the head of at one point. I'm now forgetting. But we've advocated in the past for in-state tuition for undocumented students in Connecticut. And through United We Dream, we have advised on what it would look like to have a truly inclusive immigration policy, not one that kind of picks winners and losers, but instead is thinking comprehensively about what immigrant justice looks like. And I will add that, in this current moment, I think that part of the conversation that many people are having, and there are conversations that we're beginning to have in our clinic as well, is not just what does a just immigration system look like, what does an anti-racist immigration system look like? And so we work very closely with a range of partners to try to engage in a range of strategies around these important questions.
Well, and just given the breadth of cases that are listed on WIRAC's website and the cases that you all have been involved in, you're certainly taking a look at both workers and immigrants' rights from a wide variety of angles. And I want to talk a little bit about, so for both Armando and Ramos, neither of you were students at Yale when this case first came to the clinic. And so I am, assuming that the case continues on beyond your graduation next year, this is interesting from two perspectives. One, I certainly want to highlight how much of the advocacy work the students in the clinic actually do. And I would love for you, either Ramos or Armando, to talk about some of the earlier advocacy work in this particular case. But then also talk a little bit about the experience that you're getting and how that's shaping the type of lawyers that you are going to become. And Ramos, I'm going to start with you.
Sure. So I can speak more generally about the experiences students have in the clinic. I believe Armando was on this case much longer than I have been. Generally speaking, I mean, students really drive the clinic's work forward. We take the first cut at the various documents and papers we prepare for the court. We participate in oral arguments just as lawyers do, with a lot of help and supervision from our supervisors like Munir and our other supervisors, Marisol, Mike, and Sarah. But the experiences we get are really, that of junior lawyers. We're going to come out of law school with a number of years of legal experience, working at the highest levels of impact litigation and legal advocacy. And my own story with WIRAC kind of starts a bit before law school. Is as a Muslim who was kind of watching the Muslim ban unfold and watching litigation challenging it. As someone applying to law school, seeing this clinic and this law school challenging the Muslim ban was kind of an inspiring experience for me. And it's something that drew me to this clinic. And then having had the opportunity to work on litigation involving the Muslim ban once I started in this clinic during my first year, really brought things full circle. So it's been a delightful mix of personal and professional experiences that I'm excited to take beyond law school.
And certainly taking a case all the way to the Supreme Court is an experience that not many lawyers get, regardless of how long they have been practicing. So Armando, could you talk a little bit about your deeper involvement with this matter too?
Sure. So Ramos mentioned that he thought I might have been on this longer than he was, only by a couple of months, I think. But it goes to show how each month feels like an eternity when something is as fast-paced and as involved as this case. I was, so similarly to Ramos, I was not in law school when this case was brought. I was actually still at Yale, but I was in divinity school at Yale studying theology, and saw the work that the clinic was doing on this case, and was inspired by it. I mean, I had worked a little bit with the clinic on the side when I was an undergraduate at Yale, because I was involved in immigrant rights work, as Munir mentioned, doing policy for state immigrant rights advocacy. And when I got to law school, I was dead set on being involved in the clinic, however I could be, and and this case needed folks to staff it, and so I joined, and was very fortunate that that the supervisors took me on, and really it's hard to overstate how much experience we've gotten from this case and just from our matters in general in WIRAC. The opportunities that we have. So last week on Thursday, I was representing plaintiffs in this case at what became a pre-motion conference in the Eastern District of New York before the judge we were assigned to. And that kind of experience is an experience that is not at all common for even junior lawyers. And so to be able to do that and to do that with a full, not just as a law student who's preparing for a particular kind of profession, but as someone who had DACA, as someone who has had a stake in the outcome of this case, and to be able to participate in that in this deeper way is something that's really, really special.
Absolutely. I can tell you in my almost 15 years of practice, never once did I actually get to take a case to court. They all settled before I got there, or before we got to that point. So yes, I think that's something that would surprise a lot of people, is even taking these to an initial court date is not a given. And so having this experience and moving with this through from the original case, and then through the Second Circuit, and then continuing on, and now seeing the aftermath and going back to, not necessarily going back to the beginning, but working the case again from this next angle is not necessarily a common experience, and certainly not for law students themselves. Munir, could you give a little bit of a history as to how the clinic came to be, how it got started, and when? And
Sure. So we have existed in some form roughly since 2006 or 2007. One of my colleagues named Mike Wishney, when he came and started teaching at Yale, he started WIRAC, and I joined a few years later in 2009, and we began to co-teach. And a few years ago, our colleague Marisol Orihuela joined us, and so the three of us have been co-teaching it with a teaching fellow at different times over the past many years. And so our current teaching fellow is a lawyer named Sarah Zamperin. Every couple of years we have a new fellow who comes in to teach with us. And in some ways, the clinic has, there's some constants to the work that the clinic has done. We're part of a much larger clinical program at Yale, and part of a much larger clinical community in the country, which is by and large committed to providing a pedagogical opportunity for students, while at the same time providing critical legal services to individuals, communities, and organizations that otherwise would not be able to afford it. For WIRAC, there are certain core values that we have espoused since the very beginning, which do relate to how we take on cases, for example, who we choose to work with, how we're trying to leverage the resources that lawyers can bring in service of poor and marginalized individuals and communities. And as I mentioned earlier, one of our guiding principles has been to use legal tools in support of and in connection with other forms of activism and other forms of social change. And so for the most part, we take our cases, when we're trying to decide what cases we'll take on in what is a relatively small teaching program, we are in constant conversation with our community partners to determine with them what are the cases or issues that are of highest priority to them, so that rather than us kind of sitting in the proverbial ivory tower and making decisions about which are the best cases to take on, we are trying to be in conversation with people who are much closer to the impact of the issues that are involved, in then making those kinds of screening decisions about what matters to take up. And as the clinic has evolved with different of us coming into on the teaching side. The focus of the clinic has changed over time. But really and this is something that I think Ramos spoke to earlier, really what determines the character of the clinic is the students. And the students come in, and it's a fairly, I think, typical trajectory that students have. Many of them will join in the second semester of their first year of law school and have a kind of wide-eyed a kind of expression when they look at the third-year students and what they're able to do. And it's a common refrain for students in their first semester of the clinic to say, well, I could never do what Ramos is doing or what Armando is doing. They are, they're extraordinary, and I could never do that. And half of that statement is right. They are extraordinary. The other half is wrong, though. They can do that, and they will do that. And sure enough, 2.5 years later, they are those students who the new students are looking up to and saying, I could never do what they're doing. So we are fortunate to have a structure in place where there's an incredible amount of peer-to-peer and intergenerational learning. As teachers, we're doing a certain amount of the instruction, but we also are modest about where the learning is happening. And the reality is the students spend much more time talking to one another than they do talking to us. And those conversations that are taking place, I know from my email and my WhatsApp at all hours of the day and night, there's so much learning that's happening there. And 3 L's teaching 2 L's and 1 L's, and people bringing their stories, their identities, their own kind of view of justice and law in and animating the clinic, and in doing so really defining what the clinic is about. And so there's a churn and a dynamism to that, which I think has been part of what has made the clinic a successful teaching enterprise and a successful learning and service enterprise for roughly the past 12 or 13 years.
Well, and I have to imagine too, because these are cases, as you said, that are largely brought to you by your partners, because they're the ones making the determinations as to this is an issue that is impacting a wide variety of people, or this is an issue that has ramifications that people might not necessarily be aware of quite yet. That gives both a passion and an immediacy to the work that they're doing, that the students are doing in the clinic, versus a more academic perspective of it if it were driven more by, hey, this legal principle seems kind of cool, let's see how far we can take that. And yeah, I think with all of this, what I keep coming back to is that human element of it, and really having that understanding and that immediate impact on someone, and in this case, many someone's lives. Because this, although Martine started this case for you all, certainly the ramifications of this are significantly broader. And so all of a sudden, from one man's story, this is impacting several 100,000 people. And so that's really interesting. I wonder for Armando and Ramos, have you found that people sometimes underestimate you or your abilities because you are law students, as opposed to having that ever critical JD after your name already? And how do you work through that? Or is it more a matter of almost laughing at them, thinking, just you wait, you'll see what we can do?
Well, I mean, we deal with a lot of external parties often, especially on a case like this, where there's press work to be done, where we're interacting with the court, we're interacting with a number of other firms and organizations and other parties. A lot of these external parties aren't aware of the depth and the extent of our clinical program. So there's always educating upwards to do. And our clinical supervisors are very committed to ensuring that regardless of how external parties view the program, the students are put up front. So I think, whenever something like that happens, it's easy to work through, and it really hasn't impeded our work in any way.
Okay. I'm curious too, and I'm guessing Yale's law school is in a similar situation to most of schools at the moment, trying to figure out how are classes convening? How is the work continuing? Has the pandemic affected the clinic's work in a significant way? And Munir, you might be in the best position to answer that one. How is working in the pandemic time or clinicking in the pandemic time different?
Yeah, I mean, I think that we're all, as everyone in the country and to a significant extent in the world, we're all kind of finding our way into through these changed circumstances. It's true, we've been essentially online since March, and our law school is opening up in person to some extent starting next Monday, but we'll continue to do a lot online. And the clinic will continue to do a lot of online in terms of our meetings and supervisions with students, as well as a seminar that we do on a regular basis, likely to do most of that online, just because of the constraints we're all operating under. But, you know, it's interesting because there are some things like the court hearing that Armando described last week that was done via video with the Eastern District of New York. There are some technical glitches along the way, but it's become pretty quickly, I think it's become kind of normalized that that's what happens. In another case, on Monday of this week, I supervised another student who was taking a deposition. And we did that by video. And the deponent was in one room, and my student was in a different place, and I was in a third place. And it actually worked. It worked okay. I mean, there again are kind of some challenges there to work through. So those are some of the ways in which kind of just mechanically our practices have changed. Probably more interesting is substantively the ways that our practices have changed. So we have been, since the pandemic broke, trying to also direct our resources to people in communities who are being deeply affected by the pandemic. And so two things that kind of spring to mind in that regard. One is through a number of different cases, we have been seeking to, we've been advocating for the release of detained or incarcerated individuals who face a heightened threat of COVID infection and severe illness from COVID by virtue of being in incarcerated settings. And so we have, for example, with the Lawyers Committee for Civil Rights in Boston and Wilmer Hale, we have been co-counsel on a case that's a class action case on behalf of immigrant detainees in Massachusetts, in a Massachusetts county jail. And we have, gained the release of some, dozens of individuals from those circumstances where that threat of COVID. We've also been working with a local union in the immediate aftermath of kind of the beginning of the COVID crisis to help to streamline availability of unemployment insurance for their members. And so we helped to stand up a hotline for access to unemployment insurance at a time when the state's own hotline wasn't working, when applications were only being accepted through the internet, and many of the union's members didn't have internet access. So that became kind of another area where substantively our work shifted, because that's where the critical needs were. And I think that will continue to inform our work, this fall and probably for some time to come, as we look at what both the health and the economic impacts of the pandemic are on the communities with which we work and to which we're committed.
And you've touched on a number of things that we in these tea times have had conversations about as well. So we've spoken with Margot Schlanger on prisoners' rights in general in this time frame. And we spoke with Gabir Graywal, the Attorney General of the state of New Jersey, about what their work and just both from the how prosecutors were shifting some of their focus as a result of the pandemic, and then how to protect both the citizens of New Jersey as well as the health of the prisoners, and had a very in-depth conversation between what is the difference between prison and jail, because for a lot of people that's a conflated term. And then we've also had a few conversations about digital equity and digital inclusion and the digital divide, especially at this time as it became far more prevalent all of a sudden when people realized that even, and I think the smallest number I've seen is about, 12% of the United States population doesn't have access to broadband internet, although as we have discussed, that is significantly larger than what that actually is. But what that means in real terms and the impact that has for lack of access to various services, to support that they may need, and things along that line. So it's this is another angle at which people are trying to support the community in these times and finding creative ways to do that. I'm curious for Ramis and Armando, and because our theme this year is the other, how has working in the clinic, and maybe it's a law school in general, a conversation, how has that given you insights into how the law can marginalize people, and sort of how to work within that or work to correct that? And Armando, we'll start with you.
Sure. So I think I approached this question or this theme with a kind of fondness, because one of the things that I was interested in when I was in divinity school and studying theology was that question of otherness and the power that words have. And it's one of the things that's always impressed me about the law is how much these words matter. And they have no force on their own, but what we ascribe to them. And yet they shape our lives in really meaningful ways, sometimes positively, in immigration law, unfortunately, oftentimes negatively. And I think I had some sense going into law school that I was going to be getting involved in that work, and in the work of trying to alleviate the negative impacts that those words have on people, and not just in kind of pragmatic day-to-day conditions, but I think psychologically as well and spiritually, the effect that these words can have. I mean, so earlier when we were talking, the way that I think Americans were often accustomed to talking about undocumented people was as illegal. And I know that that's true from my own experience growing up in Texas. And the effect that has is really important. I mean, the word illegal doesn't show up anywhere in the relevant portions of the Immigration and Nationality Act, but it doesn't have to in order to shape the discourse, and it doesn't have to in order to shape what we think is reasonable, what we think is unreasonable in terms of our policy choices and our advocacy. And being in law school, being involved in this clinic, taking part in that work has really just kind of accentuated the importance of trying to get the words right, and coming up with them and shaping them and creating arguments and being advocates for people to be very aware of the impact that these words can have and do have on people's lives.
Ramis?
Yeah, I think that was very well said, and I guess to take my own personal experience, growing up, the language of the law was often, I mean, I as a child through up until college and law school, most of my I saw myself only in the context of legal conversations about post 9/11 national security, Guantanamo, the war on terror, and the use of the law and the power that that law generates against people that look like me, against my family members, against my culture and my religion. And then entering law school and kind of being put in a position where you're now learning that language of power is kind of overwhelming at first, kind of being both on the menu and at the table. But it's also, at the risk of sounding trite, like imposes a responsibility, which you have to ensure that it's redirected towards better purposes, and closing the gaping holes that the law creates, and that people that look like me and the others on the screen fall into.
Well, and I have to say that one of the things, and I touched on this a little bit earlier, that I find significant about the work WIRAC doing is just the breadth of the things that you all are working on in order to shape these conversations. So it's everything from wage or employee abuse of immigrant workers. Munir, as you mentioned, the Connecticut Students for a Dream, so making financial aid available regardless of immigration status. There was work, sort of, if we're quarantine related, related to the Ebola quarantine within the Liberian community. And then Ramos, as you mentioned, work on the Muslim ban and some of the people who were directly impacted by that. And one of the things that I think I found most intriguing was the work that led to the Connecticut Trust Act. Munir, I wonder if you could talk a little bit about that, because that also has some moving parts even now, and just sort of the immigration detainer case that led to that, and then the work that actually led to creating the Connecticut Trust Act.
Sure. So the Connecticut Trust Act, like trust acts that exist in many states across the country, essentially restrict the ability of state and local law enforcement to share information or to cooperate with ICE in enforcement of the immigration laws when they encounter residents of their jurisdiction, just through ordinary law enforcement. So to, give an example, if someone gets pulled over for speeding or for a traffic violation, the trust acts are designed to ensure that that person doesn't end up getting deported for something as so minor. And the deeper thinking behind that is that communities should make decisions about how they want to deploy their law enforcement resources. And so should the federal government be able to essentially commandeer state and local police to make them a part of the federal immigration apparatus, even if local communities were to determine that that would sow seeds of mistrust between the community and police, and that they would rather work toward building trust, so that if a non-citizen resident is the victim of a crime, they report the crime, or if they're a witness to the crime, they come forward with evidence, or so forth. And so that's kind of the thinking behind it. We, as you alluded to, we initially brought litigation challenging the use of something called detainers, which earlier the federal government insisted it was, if they issued a detainer to state and local police, instructing them to hold that person until immigration came to get them. Initially, the federal government claimed that those were the local jurisdictions were legally required to adhere to those. And under legal challenge, the one that we brought, and legal challenges that were brought across the country, eventually the administration, this was the Obama administration, actually receded from that view and said, well, no, they're voluntary, they're requests. But nonetheless, it's a good idea for state and local law enforcement to abide by them. And this is so we struck we came to a settlement in our case against the state of Connecticut, but this is a good example of the ways in which litigation played a small role in a much larger movement. And what happened is that immigrants' rights groups and community-based organizations in Connecticut took what was a good but modest victory in this court case and said, we should have more. It shouldn't just be these limited protections. It should be much larger than that. It shouldn't just be with regard to the Connecticut Department of Correction. It should be with regard to all state and local law enforcement officials. And so they then set about advocating for that, and we supported them through our non-litigation advocacy. But it was very much an effort that was community-driven at that point rather than litigation-driven.
Interesting, thank you. So I have been standing in a little bit for our audience since we had some technical difficulties today, and so trying to ask some questions that I thought our audience would ask. I think as we approach wrapping up our chat today, I am curious about what might be on the docket for this fall and this spring, and what the clinic will be working on. And so Ramos or Armando, I don't know if you're still working on the same cases or if you are working on new cases, but I would love to hear what's on your plate.
Sure. So I believe Armando and I are both continuing on our work with this case, which is going to take up a considerable amount of time of this upcoming semester. And then also for me, I think one thing that I very much appreciate about our clinic is the relationships that they've developed over time. And I try to stick to a principle of making sure that I involve myself in those relationships for as much time as possible. So from the beginning of my time on the clinic until now, I've been working to help represent that coalition of immigrant rights groups that really led the charge to pass the Trust Act, and they do a number of great things, pandemic related and aside, for the immigrant rights communities in Connecticut. So continuing to represent them this upcoming semester as well.
And similarly, like Rama said, I'll be very engaged in this case. And then I'll also be, at the very least, assisting with one individual representation that we've had ongoing for the past year or so.
I think that one of the last things I'm curious about, because obviously, as we have discussed with this, law students cycle through the clinic and the cases may not yet be done. So how does the handoff work? How do you I don't, obviously I would assume as each year as students are added to the clinic, they get involved in the cases similar to you both did. So is there sort of an official handoff when you graduate, or is it a matter of if you wanted to stay involved in the case, you could? I'm just curious as to just the logistics behind that. How do you sort of watch from afar as the case you worked on continues on its path?
I could say for this case, so I joined in January of 2019, I believe, on this case. At that point, so for the first week of the semester, there was this mad rush to prepare for oral arguments in front of the Second Circuit. And those arguments happened, and then the case was kind of silent for the semester. And so what I actually really appreciated was having a team and being able to talk to that team and having the transition happen kind of naturally. Like, oh, okay, now that we're past oral arguments, what exactly is this case about? Where did it come from? What are all the things I should read? And with something that's been going on for years, that means you have hundreds of pages or thousands of pages actually that you could be looking at and maybe should be looking at. So I feel like my transition into something like this was relatively smooth. The other matters I've had, either I had some background on before law school because I knew the organizations, or we just started. And so I was at the same pace as everyone else. Ramos, I believe you joined in the middle of the summer, right as we were at the Supreme Court for this case. So maybe that was a little bit different, but that's been my experience in terms of transitions.
Yeah, I think that experience is typical. Like Munir had mentioned earlier, there's a lot of intergenerational, inter-year learning, peer-to-peer learning. So a lot of our case teams have first year, second years, third years. So the transition is often smooth. There are materials prepared, there's knowledge transferred. I think it's rare. I haven't yet seen for an entire team to be replaced by an entirely new set of people. So the transitions typically are pretty smooth.
I have to imagine that's by design. So, so I would like to thank you for joining me for tea today. And I would like to thank our audience when they see this as well. And I hope this tea provided some good food for thought. Thank you to the Jamestown Bar Association for sponsoring today's tea. Just to also let everybody know, we are shifting our program timeline a little bit to enable space for some larger programming as well. So the tea times that happen on Thursdays at 3 will now happen every other Thursday. starting September 3rd. And on September 3rd, we'll be talking about voting rights, actually with the Lawyers Committee for Civil Rights Under Law. So thank you for previewing their work a little bit. Since that tea will be exactly 2 months before Election Day, I'm going to start the shameless plugs now to remind you to make sure that you vote in November. And Ramis, Munir, and Armando, thank you so much for joining me for tea today. I really appreciate it, and I enjoyed this conversation.
Thanks very much.
Thank you.